In this lesson, what I want to do is carry on talking about the concept of the charitable trust. But now we're actually getting into the brass tacks of the trust part of charitable trusts. Because so far, all we've really done is talk about what is a charity, um, which we talked about in the previous lesson and the lesson prior in defining what a charity is and how the 2011 Charities Act comes to a conclusion about what is and what isn't a charity. This lesson is going to talk about, like I said, the creation of a charitable trust, namely the various different requirements that are necessary for the establishment and for the creation of a charitable trust. So, like I said, we're going through the basic requirements. Generally, there are 3 stages which are required to create a charitable trust, some of which you already know about and will already know about, and we will talk about in more detail in future lessons as basic examples. But fundamentally, this is an area of the law that isn't particularly controversial, it isn't particularly difficult, and it is, compared to the Van der Waal exceptions and all the stuff related to formalities and constitution, far easier. Okay, so like I said earlier on, in previous lessons, that when we get onto charitable trust, it's basically all downhill from here. This is basically what I mean. So when it comes to the requirements for a charitable trust, there are 3 that are satisfied, that are required to be satisfied in order for you to have a charitable trust. And they are all outlined nicely in the 2011 Charities Act. The first is that the trust itself has to be recognised as being created for one of these charitable purposes. Now, we know already what these charitable purposes are because we did this in the previous lesson. These obviously are found in Section 3, subsection 1 of the Charities Act, Parts A all the way down to M. And it's a huge collection, and we will talk about some of them. Okay, I could theoretically do a lesson on all of them, but then that would mean that our lessons on trust would be 100 and 150 videos long, which I'm not going to do. I'm just going to take some of the most important ones, so education, religion, and I believe poverty as being the examples, which we'll be doing in the next few lessons. The second is something that is openly stated in Section 2, subsection 1 of the Charities Act, which we also looked at in the previous lesson, which is that it has to satisfy the public benefit requirement. It has to be for public benefit. And then finally, it has to be operated as being exclusively for a charitable purpose. Okay, so it can't be half and half, it can't be anything like that. It has to be an exclusively charitable purpose for a public benefit, and the charitable purpose has to be one that is recognised by the Charities Act in Sections 3, subsection 1. Note that that first requirement is basically easy to establish anyway, given not only how many different things that are in that recognised charitable list, not only how many of those are quite vague, but also Part M tells us that basically as long as you're in the spirit of one of these, or it is analogous to one of these recognised purposes, then you fall within the remit of the Charities Act, which is perfectly fine. So, recognised charitable purposes. We've covered this in the previous lesson, okay? These are the ones which are outlined as the, quote, heads of charity under the Charities Act. Namely, we would have to satisfy that the purpose of the trust that we're creating falls into one of the heads of charities, which is cited in Section 3, subsection 1 of the Charities Act. These include, of course, advancement of religion, advancement of education, advancement of prevention of poverty, advancement of culture, arts, science, all these different things, okay? And as mentioned, and very, very importantly, at the end of the previous lesson, I mentioned, of course, that Part M of that basically gives us carte blanche to assume that pretty much anything that could be remotely considered charitable could fall into one of the categories of the Charities Act heads. The next requirement is this idea of public benefit. We'll spend more time examining the case law on this in the next lesson, but for now, just note that the requirement that a charitable trust be created for public benefit is outlined in Section 4 of the Charities Act. And what it basically says is this. It says, quote, "In this Act, public benefit requirement means the requirement in Section 2(1)(b), that's the one that we looked at in the previous lesson, that a purpose falling within Section 3(1), which we also looked at in the previous lesson, must be for the public benefit if it is to be a charitable purpose. In determining whether the public benefit requirement is satisfied in relation to any purpose falling within Section 3, subsection 1, It is not to be presumed that a purpose of a particular description is for public benefit. In this chapter, any reference to public benefit is a reference to the public benefit that, as that term is understood for the purposes of the law relating to charities in England and Wales. Subsection 3 is subject to subsection 2. Okay, not particularly very helpful. We'll get to what this means in more detail in the next lesson, don't worry. The next point then is this idea of exclusive operation. It has to be exclusively for the purposes of charity. Okay, it cannot be for any other reason. So it first has to fall into the categories of the big old list from section 3. It then also has to be for public benefit, as defined in section 4. Not very well, I might add, but it's still defined at least. And then it has to be for exclusive operation. This is actually outlined in section 1 of the Charities Act. So we go from section 2 gives us what a charity is, a charitable purpose is. That takes us to section 3, and then that takes us to section 4, and then we have to jump all the way back to section 2 to understand the exclusive operation requirement. So we have to go back to section 1 even. Section 1 of the Charities Act says, for the purposes of the law in England and Wales, charity means an institution which is established for charitable purposes only, and falls to the subject of the control of the High Court in the exercise of its jurisdiction with respect to charities. So, again, not particularly good in terms of a definition. We'll get to what this means in future lessons' time. But fundamentally, if you are asked the question, what is required for the creation of a charitable trust, it's really, 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 really simple, okay? Really simple. You have to first satisfy that the reason for the charity or the charitable purpose falls within section 3, subsection 1, the big old list. Most things will fall in that in one way or another. You could argue that pretty much anything that is relatively, at least has a hint of charitability, can fall into that list. The next is you have to, by reference to section 4 of the Act, make sure that the charitable purpose is for public benefit. And the reason for this is because there are some things that fall within section 3, subsection 1, that does not necessarily mean that it has to be for a public benefit. So, for example, private religious institutions, very private religious institutions, very specific things that relate to religious institutions, may fall into section 3, subsection 1, the advancement of religion, but may not fall into section 4, the public purpose, the public benefit. Similarly, there are some schools that exist that are particularly private, okay, that do not satisfy the public benefit requirement under section 4. So while the advancement of religion is a charitable purpose under section 3, subsection 1, the idea of it being a public benefit may not be satisfactory for the purposes of section 4. And then finally we go back to section 1 and note that in order for it to be a charity, it has to be exclusively a charity. It has to be for charitable purposes only. If there are other purposes that exist that are commercial purposes, for example, then this would not fall into the remit of charity. You could take, for example, the business that I'm operating right here, okay? It is for the you could theoretically give me charitable status on the basis that what the work that I do is for for the advancement of education. Definitely, obviously, my whole purpose in on this business is to build an education platform. I could also make the conclusion that it's for a public benefit. It is indeed for a public benefit. It's open to everybody. It is almost exclusively free in almost every single facet. But it is not for a charitable purpose only. This is a job. This is my job, and it is a venture that is obviously something that pays me money in order for me to carry on. I could have theoretically set it up to be charitable and establish it as a charitable institution. There are definitely similar businesses or similar institutions that operate in a charitable way that do very similar things to me. The Khan Academy, for example, is actually a charitable is a charity in the United States that does educational content like this. But notice here that it could fall into section 3, subsection 1, and section 4, but still not be satisfactory on the basis of section 1, on the basis of the fact that it is not a charitable purpose, an exclusively charitable purpose.